Hello, everybody. Welcome back to the Butterfly Monkey Effect channel. Hopefully, you guys are doing well and have watched the previous videos that I have put out on citizenship. This is going to be a discussion on the executive order that Trump has put out in terms of ending birthright citizenship. So, to start, one, the executive order makes a specific statement about who or what encompasses citizenship of the United States under the 14th Amendment. So this is the executive order here. Protecting the meaning and the value of American citizenship, right? January 20th. By the authority vested in me as the President by the Constitution and the laws of the United States of America, it is hereby ordered. Section 1. Purpose. The privilege of the United States citizenship is a priceless and profound gift. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott versus Sanford, which all of you should be completely 100% familiar with this case. Because this case also shows and states that there was a concept called a citizen of the United States prior to the 14th Amendment. That existed already, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility of United States citizenship solely based on their race. Well, the court did not misrepresent it, because if any of you that study trust law, right, what you write on paper is law, right? So the Constitution specifically said who? White people. So all the judge did was uphold the letter of the law. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States at birth. And they give you a statute here, 8 U.S.C. 1401, generally mirroring the 14th Amendment. And they say generally mirroring it because Section 1401 has multiple definitions of U.S. citizenship. So the 14th Amendment specifically carries with it the principle under the common law of birthright citizenship on the land. Okay, same with each state constitution, they incorporate the same thing. The rest of 1401, B, C, D, and so forth, right, have to do with birth by blood and so forth like that, right? Those are also common law principles, but we did not adopt them as the British did. We incorporated birth on the land specifically in our Constitution, not the other one around. Among the categories of individual, and to continue, right? So this section, right, the 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but are not subject to the jurisdiction thereof. A good court case to understand this, why they're going to exclude persons who are not lawfully here, is the court case Wong Kim Ark. His parents were citizens of China that were lawfully permanent residents here, living in California, specifically San Francisco, where Wong Kim Ark was born. And in that court case, they make that specific distinction as part of the criteria for citizenship by birth to be extended. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of the United States citizenship does not automatically extend to persons born in the United States. when the person's mother was lawfully present in the United States and the father was not a U.S. citizen or lawful permanent resident at the time of said birth. So there's one. Right? He's not lawfully present, or neither is she. Number two, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of a visa waiver program or visiting on a student, work, or tourist visa, and the father was not a United States citizen or lawful permanent resident at the time of the person's birth. Section 2, which is a policy, right? It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accepts documents issued by a state, local, or other governments or authorities purporting to recognize the United States citizenship to persons. One, when that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. Or two, when that person's mother's presence in the United States was lawful but temporary, and the person's father was not a United States citizen or lawful permanent resident at the time of birth. I'm not going to continue on this because the main part that I want to get to, because this is going to be the restrictions on what they want their agencies and the states to do and stuff like that. What I'm going to go is this. The question is, how and why are they stating this? National and citizen of the United States. How can this be proved as a fact? Right? Most claim that they're nationals, right? And they use the definition under 1101A21, I believe, out of Title 8. But the question is, for those people who state that specifically, how is that term used within that title? You cannot be a definition. You have to understand how it's being applied within the context of that chapter. Okay? So, in multiple court cases that I have found, of course, and I'm going back, just like I stated right here in Dred Scott, the concept of a citizen of the United States already existed since the Constitution. It was not created by the 14th Amendment. What was created by the 14th Amendment is the mode. They finally wrote down the principle of common law on citizenship of birth on the land. It was never written down prior to that, except in the state constitutions. But as a condition of being a state citizen, you were also construed as a citizen of the United States. This is how Dred Scott interpreted it. Not only that, there's another court case called Ingalls versus Harbor, Snug Harbor. Let me look. Ingalls versus Ingalls, no. Harbor. Let's see if that comes up. I forgot the first word. That's what I forgot. Right here. Trustees of Sailor Snug Harbor, 1830 case. This will also substantiate the fact that the concept of a citizen of the United States existed already. Right? It was not created by the 14th Amendment. All the privileges and immunities of the citizen of the United States are more or less established within court cases. All the court cases since the Constitution have all been compiled in one location and now put in the 14th Amendment privileges and immunities. That's literally what happened. Just that prior to the 14th Amendment, it only applied to white people. It does not anymore. So whatever you guys want to believe, so be it. That's on you. I'm not going to try to argue, debate that stuff. Now, what I have found in multiple court cases, like Downs versus Bidwell, Belmonte versus Immigration, which this is Belmonte right here. Look what they state. Citizenship under the 14th Amendment, however, is not extended to persons born in any place subject to the United States jurisdiction, but is limited to persons born or naturalized in the states of the Union. And they quote Bidwell from here. What does this tell you here? If the definition of the United States in the 14th Amendment Citizenship Clause is defined as the several states of the Union, and you were born in one of those states, what does that make you? I mean, it's obvious. Okay? Now, how are we both? Right? The concept of being born in a state automatically makes you a citizen of that state. They just chose to not use the terminology of state citizen anymore, or to call you a Californian or a Texan or anymore. Right? They grouped it all into one and called it a national. But the question is, how and where is that term being used? Right here. Section 1401 of Title 8. Anywhere else, if you go in Title 8, right, for those definitions on Section 1101, right, because the definitions at Section 1101 apply to only Chapter 12. And look at the first one. A person born in the United States and subject to the jurisdiction thereof. All these other ones are by statute. And they apply more or less for persons who were born before or after a certain period on the land, or like, for instance, Indians born on a reservation under the laws of their tribe, right? Prior to the statute being enacted, right? They used to have, if they wanted to be a citizen, they needed to be naturalized, no different than a person from Mexico. It's not like that no more. They changed that. They in themselves are construed as nationals and citizens of the United States, but they are not nationals as how we are. Their state aspect is their tribe. I don't know how else to put that, but that is exactly. And the other ones here are birth by blood, which is by statute. It might be a common law principle, but they never incorporated it into the Constitution. So the Congress incorporated by applying it by statute. Why can Congress do that? Because they have the power to determine who are citizens of the United States. I don't know how else to put that. I lost my train of thought. Key court cases to read to understand what it is that I'm saying. Because when they tell you that the definition in Downs for the United States means the several states of the Union, means that it's not a corporation, because it means the states themselves. 2, it does not include any of the territories, not one, except the District of Columbia. Why? Because the District of Columbia was attached to the land prior to states like Virginia ceding portion of their land to them. But they don't have a state constitution. Their local law is the District of Columbia. Our local law is the state that you're in. I would like someone to disprove this. I don't want your opinions. I don't want your theories. You need facts, court cases, or authors of authority, because I have made multiple videos of citizenship with multiple authors of authority, all stating the same thing that spread over 150 years. Come at me with the same thing. This right here is obvious. And this Belmonte case is a 1998 case. Can't make that any clearer. but to each their own. And with that, have a good one. This video was meant to be a short one. Hopefully you guys enjoyed it, learned something. If not, good luck to you anyway.